from the University of Georgia, from business and the law schools there. I then clerked for a federal judge, so I have some exposure to the federal judiciary as well, and then went home where I practiced law and then moved into an in-house role with a, shocking for Dalton, I know, carpet manufacturer in Dalton. And I also served on the City Council of Dalton. And as we talk about the branches of government and separation of power sort of in that horizontal way, I do think it's also important to think about how we think of government vertically and how we think about local governments versus state governments. And if we get to that, I'll talk a little bit about some of the things that may be a little different in Georgia when it gets down to the local level and how we think about powers being separated. But Georgia, like the federal government, follows this three branches of government model. And for us, those of us that were raised here and sort of live in this culture, that seems extraordinarily normal. It seems like how else could anyone do it? But really the first place that we really see this true concept of separation of powers talked about, at least in Western philosophy, is in the 18th century, 1700s. Montesquieu wrote about it in a book called The Spirit of the Law, or Spirit of Law. And he talks about this idea that separating, these are the three basic functions, and if we treat them separately, we're going to get the best government. This was a somewhat revolutionary idea at the time. This was not the way governments operated. For the most part, government was built around consolidation of power, so that the powers would not be separated, they'd be as consolidated as possible, and then the consolidated power would distribute out to sort of lower fiefdoms, if you will, some level of power just for an administrative purpose, but not to actually give up the power. But we got this idea, and it sort of became one of the pieces of the American Revolution, and it's an American model that really has now spread to many corners of the globe, not across the whole world, but the idea that separating powers is good. Well, it's not always good, right? It's not always the best idea, because sometimes you might have an executive who says, I'd really think I could get something done if I didn't have to deal with the legislative. Or you have all sorts of interplay between these branches, and expedience goes by the wayside, because when you're dealing with three separate branches, everything takes more time. Does that make sense? So we had that same experience in Georgia, but we don't have all of the similarities. And I made a few notes of things that I sort of wanted to maybe mention in hopes of kicking off a little bit of conversation around this. We have the bicameral model that's the American system. Anybody knows that there's one state without bicameral, right?
It's Nebraska.
Nebraska. They have decided they just have a house. They do not have a House and a Senate. There's just a single chamber in their legislative body in Nebraska. I do not know, Governor, who they blame things on in the legislative process, because in a bicameral model, you can always say that the Senate's holding us up or the House is holding us up. I don't know what they do in Nebraska. Maybe I should take a Nebraska newspaper and see what they blame it on.
Probably blame the governor.
That's true. Now, we talk about the executive, and there is a lot of conversation, and this is mostly happening at the federal level, but it's not entirely untrue at the state level. The executive branch really has a lot of dynamism. Right, so the legislative branch is sort of what it is. There's a House and there's a Senate. And yes, they have staff, but that's what they are, the House and the Senate. And the judiciary, for the most part, is courts. But now, when we talk about the executive branch, we have what some people have sort of called the fourth branch of government, which is the administrative state. So in Georgia, we've got the Environmental Protection Division of the DNR. The federal government has EPA. The administrative state is where almost all government employees work, in the regulatory state. And so it is, in many cases, gives the appearance of being almost a branch unto itself. They make their own regulations. Usually, they have to have some sort of statutory authority to do so, but once they have it, they're a lot of times given broad discretion. I need you regulate this whole field. You take care of it. They've got their own quasi-judicial system for people who complain about it. And you have to go through all of that process before you can get the opportunity to go to the courts. So it's this entire other branch. It's in the executive branch, but I don't want to speak for the governor. I think he could probably attest it, certainly at the federal level, but even at the state level, it's not as easy as just the executive snapping their fingers and saying, get in line, to the administrative state. And so there are challenges as far as how does that work and where is that accountable. And there's a lot of discussion of that. As I am a little bit of as you can already see, I'm a hands talker, but I'm also a little bit visual in the way I think about things. And if I think about the three branches, to me, I think about how they relate. So the legislative branch relates horizontally. Right? There's a House and a Senate, and they relate horizontally one to another. It's a collection more or less of peers. Right? The executive branch, at least in theory, is unitary in nature, in the sense that it doesn't relate, it is itself. And then the judicial branch, in my mind, is a vertical picture, right? So there you have courts and then sort of a hierarchy. There's a chain that you would move up and down. So that's part of the structure if you think about how the government relates to each other. But I want to talk about why Montesquieu and others got into the business of separation of powers in the first place. What do we think is good about that?
The separation of powers.
Yeah. Why are three branches better than two or one?
Checks and balances, really. I mean, powers need to be separated. The king can't have all the power because how do the people decide if the king is doing something wrong? That's why you have a legislature.
Well, why don't we just elect the king?
Well, then, I mean, even if you elect the king has all the power. You have to have a legislative branch. You have to choose representatives to go and vote on things, represent your county or your district.
Well, why don't we just have two branches and we say the king can only have the power that's in the Constitution, and here's the judicial branch. If the king steps out of line, they can invalidate it. We're electing the king, right? If you say we need elected representatives, why don't we just elect one representative? And so instead of having to fight with 180 people in the House and 56 people in the Senate, 236 people go to the General Assembly in Georgia, and a cast of thousands appears to descend on Washington, D.C. when they get ready to make laws. And all of these voices and all of these, and we end up getting sort of this jumbled mess. Why don't we just say, you're the one?
Well, you need a plurality of ideas. I mean, and in a legislative branch, you need different ideas, because if you have one king, then that one king might be extremely conservative or extremely liberal, and then you just have the judiciary saying, no, you can't do that. But I mean, that's not how government works. Government works where you have multiple ideas coming in.
Well, what if they're elected? If they're elected and they're extremely liberal or extremely conservative, isn't that what the people want?
I mean, a lot of dictators have been elected, and then guess what happens there?
I'm not quarreling with you. All right, yes, sir.
It's just too much power in one group. I mean, one person or one institution.
Why don't we trust too much power in one institution or one group?
Because they could be biased. They could be self-serving. They may have their own agenda. They may not promote the general welfare of society or civilization of that nation.
Yeah, I like that. Did you have something you want to add on that?
It'd be too easy for them to create and change law.
Too easy. And we want to make it hard. Why do we make it hard?
Make it a slow process.
Slow process. What's good about a slow process of making laws?
It ensures that the foundation of what the country is built on doesn't change.
Okay. Yes, ma'am.
If a law takes a while to actually become a law, it allows for people to realize that they still want or do not want it based on how times change. Like, it gives time for people to think about if this is still something they want.
Okay, y'all get that? Let me. Can I add on that? Because this isn't contrary to that. It also allows people to order their affairs. Right? Let's say I want to open a new business. Who's a business student or maybe interested in business at all? All right. You want to open a business. What do you hope is true 10 years into your business? That you're making money.
You're making
money, profit, your customers are happy and pleased.
And can you do that, or what are the chances that you can do that in a world where the rules keep changing?
I mean, if you change along with the rules, then the chances are higher.
So
But
you-
if you stay the same, then you're going to lose people. People are going to lose interest in you.
You open a business, you buy a piece of equipment for your business. Let's just say you're a really capital intensive business. You buy $1 million machine that makes whatever. And tomorrow, that $1 million machine is out of environmental compliance because of its emissions. Okay, 10%, I pay somebody who can make it retrofitted, and 10% it comes into compliance. And in May, it's out of compliance again. The standard just moved. Wait a second. All right, how much is it getting in compliance now? You invested in reliance on some sort of model. Now, I'm using environmental compliance. It can be anything. And so part of allowing people to order their affairs is when we have, like in our system, a free market or capitalist system, people are investing based on some set of rules, and they are predicting some amount of return. Now, they have to make their customers happy to get it. But now if the rules change, all of a sudden, where am I? I'm out of luck, right? So we want slow legal process in part so that we can predict, right? So that's a good reason to want slow legal process. I think, and I apologize because I do not know names. Go ahead.
I'm Chris.
Chris.
Also, it could force cooperation. Like maybe there's different factions, and the process forces them to maybe make cooperation in a sense to answer a certain problem.
That's right. That's this point. That by separating out the power, we make people work together. Because nobody has sort of one ring to rule them all, right? Nobody has the power to unilaterally make things happen. We build it in, even without sort of considerations of partisan politics. Just the fact that we have other people at the table. One of the main features, if you go back for those of you that are really into this sort of issue, one of the main features that's talked about in the Federalist Papers, which was part of what we sold the Constitution as offering to the citizenry, is this idea that when we were building a country, when we were coming up with what we wanted to do from a structural, architectural standpoint with our government, we wanted to avoid tyranny. Why did we leave the king? Tyranny. That's you look Declaration of Independence. So if you look at the Declaration of Independence, this is America's letter that says, death to all tyrants, right? Tyranny is bad. Declaration of Independence. Constitution. God, please keep us from becoming tyrants ourselves. Right. The entirety of the Constitution's main articles, before you get to amendments, is designed by people who were afraid that they themselves would become tyrants when they had power. And so, what's the best way to keep yourself from becoming a tyrant? Don't give yourself all the power. Divide it up. And one of the main features of our Constitution, as opposed to some of the other opportunities, was that we gave big powers. People wanted to give little powers, going back to the, well, can we have a court and say, you don't have much power, King, and the court will be a check on that. The idea was, well, if you have little power, you don't really care about doing your job very much, because what are you doing to do? But what the founders, and Hamilton wrote a lot about this, what the founders really believed was if I give you big power, you're going to protect it. You're going to care about your power. And so when the judicial branch starts to encroach on your power, or when the executive starts to encroach on your power, legislature, you will fight for it because you got something worth fighting for. That was the model that they decided on. There were other models in play, but that's how we got this model. Now, Georgia, of course, is a little bit different in how we do all of that, and all states are, and none of them are perfect. We think of it in terms of like these three clean, clear silos, but they're not, right? We don't have a unitary executive. Just one example, the executive in Georgia is the governor, right? The executive power of the state of Georgia. But does the governor of Georgia have any constitutional authority to commute the sentence of death? No. State Board of Pardons and Paroles has the sole constitutional authority to commute a sentence of death. So this unitary executive doesn't have all that power. So even within that branch, there's division, right? So you see that? You see how that works? There's different pieces of there. In the legislative, had a conversation with one of my coworkers the other day. Georgia has a lieutenant governor. Doesn't run ticketed with the governor, right? Runs as a separate candidate, is elected separately. What is the lieutenant governor's job in Georgia?
Preside over the Senate?
To preside over the Senate. So is the lieutenant governor in the executive branch?
Yes.
Do they have any executive responsibilities?
No.
Only if we lose a governor, right?
Of course, yeah.
So that's kind of weird, right? You're elected to what looks like an executive piece. You look and then you look at the federal model, and you got the vice president, who is also the presiding officer of the Senate, right? But never spends any meaningful time there. Because in the federal system, the Senate has said, we don't want to hear, they're only there to vote break ties, and they call them if they know there's going to be a tie, right? Otherwise, and of course they're there for like State of the Union, ceremonial things, but they aren't there because they don't get a vote. And the rules of the Senate in the U.S. essentially exclude them from any meaningful activity. They sit there and hold a gavel all day. But in Georgia, as the presiding officer, and the way the rules of the Georgia Senate have evolved over time, it's an extraordinarily powerful office. It's similar to the power of the speakership on the House side. But that's a choice, right? The Senate makes its own rules. It doesn't have to afford the presiding officer that much power. All the Constitution says is you're the presiding officer. The Senate decides how much power that means. Does that make sense? And so that's a little bit different than we do in the federal system because we use that piece. And the last thing before we sort of get to full-on questions that I wanted to talk about as far as how power gets separated in Georgia is a historical note. Because I talked to you about how this all seems common and ordinary to us. Anybody from Savannah or the coast? No? Okay, all right. So 1796, the Georgia General Assembly created a court in Savannah called the Mayor's Court. Guess who the presiding judge of the Mayor's Court of Savannah was? The mayor. That lasted until the early 1800s. And it was a small claims court. I mean, it was so city ordinances, failure to pay, longshoremen and ship people, and those sorts of things could be brought in there. I bring up the point to sort of introduce the next piece, which is how do we think about it at local government level? What's a mayor?
The chief executive of the city.
Chief executive of a city, but what do they do mostly that people see them do? They preside over a city council. They're the presiding officer in a legislative body. Some cities, depending on how their charter is written, the mayor can vote. Some cities, they only vote if there's a tie. And at one time, the mayor of Savannah was also the judicial authority. So here's somebody who's elected who, by virtue of their job, is exercising 3 different functions of government, which we historically and normally think of as, they have to be separate. But the Georgia Constitution, interestingly enough, has actual language about separation of powers and does not apply to local governments in that respect. What does that tell us? Any ideas? The lines get blurrier the closer you get to home. Why might that be?
Because when you're at home, you kind of want, if you're making change, you want it to happen fast. And if you have the separation of powers, then that kind of slows down the process a little.
We want to be able to respond quickly. When I was on the city council, if somebody called and said, my neighbor's dog is barking, they didn't want to hear, well, I got to call 20 people. Right? Okay, I think that's right. So you want expediency. What else? Anybody from a really small place? Where?
Royston.
Yeah, Royston. Smaller or bigger?
I don't know, trying to be bigger.
Well, it's more remote because I'm from Dalton. I can tell you that. I'll take Tryon. It's its own place, right? You get to a really small place. How many people really want to be involved in local government at a given time? You don't have that many people. So if we start separating everything else, we got to start going and recruiting people to want to take these offices instead of let's get the competent people in, right? Is that a valid reason to say, what's one more? And if you don't, I'll jump in.
The Constitution doesn't mention local governments. Like it gives all the powers to the states, but the state is ultimately what determines if they give and what power they give to the local government.
Yeah, it doesn't implicate the federal Constitution at all, right? States are allowed to do what they want. Why would Georgia's Constitution sort of fuzz up and leave alone the idea of a local government having strict separation of powers? You got an idea, Chris?
Oh, I was just gonna add, yeah, states have policing power, but localities, they're nothing more than creatures of the state. They derive everything.
So they're
from the state.
they're incorporated in corporate. Now, in Georgia, there's a little twist there. Counties, your 159 counties, which by the way is the second most in the entire country, and by landmass the smallest average county size. We like counties. Counties are constitutionally created entities. They are not creatures of the legislature. They are part of the state constitution in Georgia, which is an interesting little twist. But here's another reason why local governments might not be the same. Now, this may not be the same in Metro Atlanta and Atlanta, where you have this big, large population. But what did we say about why we had separation in the first place? We wanted to avoid being what? Tyrannical. Tyrants, that's right. I live in Dalton. 30,000 plus or minus people. They know where I live. Right? So part of the reason of separation of powers is we don't want somebody to aggregate so much power that they're unaccountable. We don't worry quite so much about that in local politics because, they'll come to the city council meeting. They'll come to the county commission meeting. They will be there. They will call you. They will see you at ball games, and they are not afraid to walk up to you. But, and I don't mean this in a bad way. How many of you have personally seen your member of Congress? I don't care if it's your rep. If you live here, I guess that's Doug. Or your United States Senator in the last month in person. One. Right? They're remote. And it's just the nature of it. The farther you are from it, so your concern about an unaccountable, disconnected tyrant, king, is greater the further they are from home. And so there's rational reasons to say in local government, we're not quite so worried about that. We're not going to be so severe in the way we think about dividing powers. Does that make sense? All right. Those were the notes that I wanted to make sure we talked about from separation of powers. I hope you have questions. It's better with questions.
So you said that part of the reason why we had separation of powers, or was we gave some sectors a lot of powers because that they would have a tougher time having it taken away. But it seems as though, and this is the federal level, that the legislative branch has kind of taken away a lot of their power. For instance, we don't declare war anymore. We kind of just let the president decide that.
Whose fault is that?
It's the legislative branch.
And why?
Because they're giving away all the power.
Why are they doing it?
Probably because they don't want the political backlash of having to vote for something.
they also don't want to take it to the courts and then have the Supreme Court tell them this is your limit on power.
They don't want, in other words, they don't ask the question because they don't want the answer. That's possible. That's possible.
When was the last declared war in the United States by the Congress?
Yeah, I was gonna say,
I think it was World War II.
that's right.
That's why you call Korea conflict, you call Vietnam conflict. It was never a officially declared war.
Operation Desert Storm, all those sorts of things where, and then you have the war powers resolutions. You'll have to explain that to me because I read stuff about it, I think, it's one of those where you might be just telling yourself something to make yourself feel comfortable that, okay, yeah, I must be right. Congress does some strange things from time to time. It is, I think, a valid observation and criticism that this model was built around the idea that people would jealously protect their power. And that has not always been the case. I think that's a valid criticism. But understand, what is ordinary and normal and everyday to us, these people were building from essentially whole cloth, right? They were building it, expecting it to be done a certain way. And to be fair, other parts of the Constitution haven't been adhered to either, right? So, as a political science standpoint, not as a policy, if judges, or your chief was here, I hope y'all, judges can't engage sort of on policy things, and this is not meant to be policy. But when you look at the original structure of the United States Senate, who put people in the United States Senate according to the Constitution? The state legislature or the state, right? The government of the state. Put folks, and why? Why did they do that? What was the point within the structure?
You had the representative body of the House that, is purely representing, and then the Senate, equal representation for every state.
And so why in the Senate, those two people from each state, those two senators, why would the original structure, what was the rationale behind the original structure that said those people don't come here by direct popular election, they come here as an appointee of the state government? What would they maybe have been trying to accomplish there?
Protect the state's rights. So when going into the legislature, that it wasn't impeding upon the state's rights.
States' rights is a loaded word.
Okay.
So let's say state interest.
Yeah, interest. Yeah.
Right? Would a federal government, which one half of the legislative body was directly elected by state government, the state government, pass legislation which created what are commonly called unfunded mandates, create a financial burden on the state? If you were a United States Senator and you held office by virtue of the governor and General Assembly of the state of Georgia, and they were considering legislation which was going to bankrupt the budget of the governor and General Assembly of the state of Georgia, how inclined would you be to vote in favor?
Not fair.
You'd say, well, I may need to get out my telegraph and talk to the folks at home and see how we could work this out, right? And so that was the model. Now, that may or may not be good or bad. I'm not passing judgment on the policy. That's what they were looking for. And we now have direct popular election of United States senators, and there's no organizational systemic incentive for any member of Congress to consider the ramification directly on their state government. Not in the system. I'm not saying they don't. I'm not saying they don't. Don't hear me say that. I'm saying there's not a built-in provision that forces them to do that. Does that make sense? So when you think about branches of government, separation of powers, I would encourage you to sort of think about, okay, why? How could it be different? It could be different, right? We know that. And how would that look and how would that work? How do those sorts of things fit together? Does that make sense?
Yeah.
What other questions do you have? I know you got questions. Yes, sir.
There's one question I was thinking about. going to Federalist 10 and Federalist Papers, Madison talks about, like the Republic, like to be governed by good men of character. I just wanted to ask, what's your interpretation on that? Like, what's your view in terms of good character? Like transparency, the person to have transparency, like, what's your take on that?
What is the measure of good character?
Yeah, like when he was writing about it, like that specific part of that.
So, I mean, I guess my opinion is as valuable as yours, right, on that respect, but I'll give it to you. I really think what most of the founding generation meant when they said character was one of two things. One was sort of the puritanical character, right? The idea that you would be faithful in marriage and chaste outside, all those sorts of things. I don't think that that's what they were talking about in Federalists. I mean, but you think so. When we use words, it is important. I appreciate the question because it's important to think what it meant to them then. I think the other common and to me the most obvious reason in that context is truly fundamentally trustworthiness. So if you come down to what is good character, the ability to have what you say be true, whether you assert it or whether you guarantee it. Right? If you say, I will do something, it's true. If you say, there's 10 people on the other side of the room, there's 10 people on the other side of the room. It's assertion of fact or assertion of a commitment. Either one is true. I think more often than not, I think that's the sort of character that you're hearing referenced in papers like the Federalist, because the other would sort of not fit. I mean, I don't necessarily say it wasn't culturally important to those people in that place in that time, but it doesn't really have a lot to do with the discharge of your public duty, which I think was the point of, when they were writing Federalists and other similar documents. Does that make sense?
Yeah, thank you.
And I think it's fair to point out, though they were obviously all male and believed that way, another example, we cleanse language. Right? When they say good men of character, in their day and age, that was not gender exclusive. Men meant people in that context. If anybody speaks Spanish, right? So in the Spanish language, when you use the masculine plural, it's universal, right?
Yeah.
Most languages were that way, and English certainly was. And over time, we've migrated to an age where you have to say both. But that's just a lot of times it's easy to look into history and sort of say, oh well, they were saying it this way. It's not the way the language was spoken then.
And if I'm correct, Dalton has a very decent sized Hispanic community, right?
Yes, we do. Proud of it. Yeah. The question was, does Dalton have a large Hispanic community? We absolutely do. Yeah. It's our manufacturing community drove a lot of in-migration through the 90s and early 2000s. What questions do you have? Yes, ma'am.
You said people know like where you live, it's all like that. Is it ever a bother when people come up to you and see you in public or when you're famous like that? They want to talk to you about like their issues or whatever.
I think it's probably more a bother to my wife than it is to me. I mean, I am, I love people. I mean, I really do. So when people come, it's a little bit awkward now because people have known me as being on city council, being in the state legislature, and I can't talk to them about most of the things they want to talk about now because of my job. And if you're a judge, you can't say a lot of things that you could say before. And so it's not that it's frustrating to talk to them, it's that it's disappointing because I like to help people. I like to be able to, oh, well, call this person and that kind of thing. But no, I don't know where everybody's from. I know Royston, right? And trying. I love my hometown. I don't know. I hope y'all do too. Like, I hope you have some place at least where you feel like, man, this is, all these nice people live here. And it's not that we're perfect, right? But it's cool. So when people come up to me, I like to look at it as an opportunity to help.
Yeah, for
Right?
sure.
I mean, I'm thankful. So if y'all don't ask another question, I'm going to give a boring talk for a second. All right. So one of the things I tell younger students than you, but it applies to you too, is that there's so many ways that people get divided in our society, in our culture, in our world today. And most of them are not helpful or in any way sort of productive, and most of them are hurtful, I mean, the way we think about it. But I do have a division that I observe. I've observed it from a career in law and in the carpet industry and everywhere, and that there are generally two basic categories of human being. Now, this doesn't have anything to do with race, ethnicity, religion, whatever other thing that people are normally divided on. It has to do with the way they look at themselves. And so I call them get a value people and be a value people. All right? Hold on, I won't hurt your brain too hard. Get a value people. Now, shoppers in the room, do not hear this as a criticism of coupons. Get a value people, look at the world, and they see a place where they are trying to perpetually get a good deal from the world. So get a value people, if they get a job and the job pays $100, they are thinking, what is the least amount I have to put into the job to get $100 paid? They're getting a value. I put the least effort in for the maximum return. Be a value people, get the $100 job, and they say, I wonder if I could be the best $100 worker ever. Could it be possible that when somebody pays $100, they could know that no one had, I am being a value, right? So I am offering value. Now, get a value people think that be a value people are chumps, suckers, right? They're getting used by the system. You're working so hard, I'm getting the same, I'm not doing anything. Who gets promoted? Be a value. And when they get promoted, what do the get a value people say? That guy? I've been here longer than him. They don't get it. They don't get it. Who gets more opportunity for advancement, not even promoted in new jobs? Be a value people. Who are happier? Be a value people. I am not as old as some, but I'm older than most of y'all. I'm telling you, I've seen them come and go. Be a value people are happier people. Sometimes they're tireder people, but they are happier people. And I say that in this, your question made me think about that. Goodness, why would it ever bother you for somebody to come to you asking for help? I mean, it's disappointing if you can't give them help, right? What a wonderful gift somebody's given you. My mom had her knee replaced recently. My mom helps everybody on planet Earth that she can help. She won't ask her friends, her neighbors, to come help her. I'm like, Mom. I was like, don't you like helping people when they're sick or in the hospital or all this stuff? Oh yeah, I love it. I said, but you would deprive all of your friends of the opportunity to do that for you. Oh, okay. Well, that's get a value, be a value mentality is look for people to help. You will always have enough. You really will. I mean, I don't know people that I would categorize as be a value people that somehow run out because everybody's looking out for them. Everybody wants them around, right? I mean, they're dying to have somebody like that around, and they don't know why. So whatever you do, wherever you go from a career standpoint, be a value to the people around you. I always, y'all are moving up the educational. I usually give that like in lower middle school kids from a school standpoint who, if you're a middle schooler and maybe if you're a college student, you've gotten to the point where you don't want to learn everything. You just want to learn the things that you're getting credit for to get out, right? But you don't know what you're going to need to know to help that one person that's going to need you on that one day. So why would you walk past an opportunity to improve and to learn and to get better? Just because you got something else planned for today that really isn't that important and isn't going to make you any more useful than anybody else? So while y'all are here, learn, grow, get as much as you can in so that you have an opportunity to get out. I can't promise you that everything you learn will be needed in your future life. I can't. But I can promise you that what you don't learn, you will never use. Right? It won't help anybody. What you don't learn will never help anyone. Only what you learn can be useful. So experience and learn, all those sorts of things. Anyway, that's a sidetrack. That's not even the point of the story today. But you inspired me. You got me excited. What other questions do you have?
Yes, sir. From the carpet industry to the Supreme Court, what happened in between?
Oh, that's a great question. Thank you. I should have given some. Okay, so I went home to Dalton after clerking in Atlanta. I practiced law and had some friends who approached me and said, "Hey, look, it's an important time. It's always an important time when your friends come and ask you to do something. It's a really critical time. It's an important time in Dalton. We think you ought to think about running for city council." And in a fit of insanity, I agreed. I talked to my wife, and I thought my wife would say, "Oh, we got small children." No, she said, "If you think it's important and you think you would do a good job, well, then you ought to do it." What a terrible thing to say to somebody. Well, because I think it's important, and I think I could do a good job. So yes, I got on the city council. I was there. The governor knows Dr. Don Thomas, who was my predecessor in the state legislature. And we were in the same Rotary Club, and he started saying that I should go to run for the General Assembly. It was not really something that I thought about doing. And I thought, well, I don't know, but I like Dr. Don, and I trust him. He's a good and honest man of character. So I talked with him and ultimately decided that, yes, I did want to go be in the General Assembly. Well, the reality is I've always loved courts. My dad was an assistant district attorney when I was very small. He then transitioned into the business world. Judge Panell, who I ultimately clerked for, was this fixture in my life my whole life. And so I love the law, I love the courts, I love that world. But the reality is I had sort of put in my head, okay, I'm in the legislature, I'm a corporate attorney, I'm an in-house corporate counsel, not the traditional model, historically speaking, to advance into the judiciary at that point. So I sort of put that on the side burner and not really thought much about that. When some friends, again, friends come to you and tell you should think about that, said, "Hey, there's going to be some turnover in the appellate courts in Georgia, and you like the governor likes you, y'all have a good relationship. You're the right kind of person. You ought to think about putting in for it." And I went home and prayed about it and talked to my wife, and you know what she said? You think it's important? You ought to do it. Or at least put in for it. So I did. So I put my name in for Governor Deal's consideration, and he saw fit to put me on the Court of Appeals. And then when a vacancy came forward on the Supreme Court, same thing, put my name forward. And he saw fit to put me there. And he's heard me say this before, so it won't be new to him. But I did tell him that I will try to prove him right. Because I'm just a guy from Dalton, right? So now I'm sitting on the Supreme Court in my home state, and so I'm thankful for the opportunity and try to, do my best to discharge it. I love it. I love the work. I love the people I work with. It's really gratifying. And the reality is, if people were perfect, right? My backstory, my identity wouldn't matter at all, would it? Right? If I had the ability to perfectly discharge the law in every case without fail, I don't even need 9 members of the court, right? You just need 1 if you got that. But the reality is we come together and try to minimize one another's errors. And so I'm thankful that I bring a different perspective. We talk a lot in our culture and our times about diversity. And I think diversity of experience is one of the most valuable diversities there are. So having been in a court, I'm the only member of our court who's ever been a corporate counsel attorney. I've ever worked in a business world. I'm the only member who's ever been on a city council. Now, that doesn't mean that it changes whether the answer is right or wrong. We're trying to find the correct legal answer. But as we do that, we bring our experiences to bear, pushing against one another. Thinking about, okay, I read it this way, you read it. If we all read it this way, the chances of us being right is pretty good. If we don't, we should sit around and talk. Why do you read it that way? How do you come to that conclusion? How do you put this all together? And we continue to work down. The overwhelming majority of our cases, like way overwhelming majority of our cases, has the same vote count as the Supreme Court of the United States, and that is 9-0. Overwhelming majority of cases decided by our Supreme Court, by the Supreme Court of the United States, are decided 9-0. You just don't read about it. You read about 5'4", 6'3", and all the hot button issues. But that reflects that most of the time, when we push on each other, we work, we're getting to some consensus and some agreement about what the law really says, and that's the goal. So anyway, I love bringing that perspective to my work, but it's not a function of, do I decide my work based on the perspective? I hopefully try to leave all of those. I tell people all the time, you put the robe on, right? We don't wear it every day around the office, but you get, metaphorically, you trap your own biases and prejudices in, it's conscious, right? You trap that in, or put it away, however you want to think about it, and decide what's the law. What is the law, and where does it intersect the facts of this case? And that's it. That's the job. And so I enjoy doing that. I mean, it's sort of like, anybody like puzzles? It's the ultimate puzzle. You get a file from a trial court and all the arguments about how to put it together, and you try to put it together and find where's the law. Any other thoughts or questions? Or yes?
Sorry. I have two questions that really relate to each other at all. The first is, what is your stance on I had the word.
Give me the second question.
I'll give you the second question. From a judicial standpoint, especially in 2019, we kind of saw the heat up the most. What was it like for all the abortion laws going on from a judicial standpoint?
Well, I mean, from a policy standpoint, because I'm a judge, I can't speak to the policy questions. The interesting thing is, those cases haven't come through the state courts. They're being litigated in federal courts. And so, you know, I'm like you, I'm a spectator, right? I mean, I can watch the TV and hear what pundits say. I do not go in and read briefs and cases in other courts because I got plenty to do in mine. So my judicial take is that the judiciary is not to be worried about those sorts of things. We take the cases that come to us and we decide them to the best of our ability on what the law is, not what's trendy or what's popular or what's hot. Does that make sense?
Sure.
All right, first question, what was it? Did you lose it?
Well, I have a follow-up question.
Okay.
Do you think that states should be allocated more power than was what granted to them?
I think if I answered that, I'd violate the canon of judicial ethics. That's a policy determination of where power should be allocated. I think there's good arguments, but I can't express an opinion. My opinion. Is that fair?
It's fair.
Did you think of first question?
No, but I thought of another one, buddy.
Right.
So I've always been concerned with how immigration courts are run by the executive branch. Do you think it should be placed under the judicial branch?
It's sort of the same scenario. I mean, my personal opinion is irrelevant, and I shouldn't express it. I mean, it could be done. There are resource allocation considerations that would have to be considered. I mean, right now the federal district courts and the federal magistrate courts would not be capable of processing that volume, just literally human hours. They could do it, but it would just be a policy choice.
You talked about being elected, people coming up to you and everything. I'm from a small town here in Georgia that has an issue right now with a couple civil rights lawsuits against it.
Okay.
And
Don't tell me what city.
My question is, where do you think the line should be drawn between being a public figure and people being able to come up to you, and how responsible you are to the voter?
Meaning, should there be some accessibility limit?
Yes.
I really think, as a practical matter, I think that's up to any individual public official, in the same way it's up to any individual, right? You retain sort of the inherent right to say, I don't want to engage with you right now. You can't. That's true whether you're a public official or not. Now, Governor Deal can tell you that in political life, that has consequences, right? If you get the reputation of being somebody who blows people off, avoids people, then the electorate may consider that in their choice of who to elect next time. But that's a choice, and I'm sure that the governor knows, as I do, people who have successful may not be the right word, extensive public service careers that have two very, very different philosophies and approaches to doing that. People who are out everywhere all the time, meeting everybody, shaking hands, kissing babies, that image, and people who are very distant and very removed, and that's their strategy, and they get their information from a smaller circle of people who maybe those people are connected. I don't know that there's a right or a wrong. That's the beauty of a representative system of government, is that the voters are empowered to choose who they want to represent them and what's important to them. Is it important? Is your policy or issue position or party or whatever it is, gender, whatever I get to pick as a voter what's important to me. And if I want to place your accessibility to me on that chart and how high I want to, I get to do that. Does that make sense?
Yeah.
Chris, did you have something too? I saw a hand.
Oh, no, I didn't have my hand.
Okay, I thought you raised your hand earlier. Yes, sir.
What's the day in your life when you go to the Supreme Court?
That's a really good question. So they're all different. So I'm thankful. I will tell you, I felt the same way when I was in the legislature. The availability of smartphones and laptops and Wi-Fi. I can genuinely say that my public service career would probably not have left Whitfield County, which is where Dalton is, but for those sorts of devices. I could not have maintained my job in the corporate world. I could not maintain my relationship with my wife and my children in a world where the only way to get your work done was to go to Atlanta and be there extensively. That's not a lifestyle. That's not where I wanted to live or how I wanted to live. So I generally work from home. I have a home office at least one day a week. And we depend on what the week looks like. Those are actually, if you talk to my staff, they know it's coming. When I have a home day, those are my most productive days because I'm not getting interrupted. I don't have meetings all the time. I can sit down there and I just, create volume and spit it out to them. But on the other days, it depends on where we are in the court sort of cycle. The court works in more or less a 2-week cycle. We have either an argument week or a bank week. Arguments, you know what that is, that makes sense. You would go into court, we hear cases. Appellate courts don't have juries and witnesses, so our arguments are 20 minutes per side, 40 minutes per case, and we put several down per day, and we hear those cases. If we have a bank day, I always tell people, lawyers and judges use foreign words. We don't pronounce them correctly in an effort to confuse the public. Bank is just a French word, en banc, altogether. That is an appellate court meets en banc. It meets to generally vote on or dispose of things. So tomorrow, I was telling earlier, tomorrow our court will have a bank meeting. We will dispose of dozens of votes. So we've all prepped and worked. So like my normal day before that, if I wasn't coming here, which thank y'all for giving me a reason to come here, it would be a frenzy of back and forth last minute edits with all of my colleagues. Thankfully, because everybody knew I was coming here, I sort of got that done a little bit. I said, I'm not going to be available on Wednesday afternoon. Get me your stuff in earlier. And so if I have something that somebody has a real big problem with, we may not actually vote on it tomorrow. We may push it off to our next meeting, which is no big deal. But for the most part, that's how we're doing. So you got editing day. You sort of get into a cycle of days when you edit. Then, when the legislature is in session, there's various meetings and people are watching bills. We try to stay out of that. Number one, separation of powers. We don't have any business being over there. And number two, they'll let us know if they need to hear from us. They've got plenty of voices over there engaged with that process. But throughout the year, it's sort of just that cycle. You're getting ready for arguments. And so we'll bank tomorrow. Next week, we actually have the building dedication for the Nathan Deal Judicial Complex, the Nathan Deal Judicial Center, which is our new home and new building, which we are thankful for and love. So as soon as that's over, I've already really started a little bit, but from a functional standpoint, I will go into that and spend several hours this weekend preparing for oral argument next week. So we'll have building dedication, which will kill a day, so you won't be able to prep, so I've got to move some of that somewhere else, got to find the hours. So there's not really a typical day. There's a long way of answering that question is there's not, the argument days are structured, the bank days are very structured. The rest of the days is you trying to figure out how to shuffle your work to be ready for those days. Does that make
Seems like a schedule mess.
You know, if you keep track of what you got to do, it's not so terrible. And I'm lucky. We all do on our court. We've got great staff who, if I start to forget something, they'll remind me fast. They'll say, Judge, you need to.
Just one more. I read that the Supreme Court, when they're like, when they come together, they usually own like almost like a hidden room, and they have like the youngest justice, or like the newest appointed justice, go out and grab it and then bring it over, and then that's how you all decide. Do you guys do that too?
We don't do it quite like they do. The junior justice on the court does by reputation. I mean, obviously, I've never sat on that court, and I don't know. But this is what they all say. They do. They sit closest to the door. If somebody sends a message into them, that's who gets up. If I think, at least I always heard that that's the one who gets coffee. I mean, I can't really imagine, right? Like in our court, there's a table, and there's some. If you want coffee, or if you want some, go get it, right? I mean, that's sort of how it works. I mean, there are some. It is a very traditional process in a very traditional court.
Right.
And so where we sit at the table is based on our seniority on the court. Where we sit on the bench when we go into court is based on our seniority on the court. All those sorts of traditional, procedural things. The Georgia Court of Appeals has very similar traditions, but they're different. They sit in panels of 3. There's 15 members of the court. They sit in panels of 3. The way they circulate their court cases is determined by seniority. And so there's a lot of those little pieces that are out there. But no, we don't have what looks like hazing, right? I don't think we have any of that in our world. At least I haven't experienced it yet. Maybe it's coming, right?
Would you talk to them about the expansion of the courts, both the Court of Appeals and the Supreme Court, and the reshuffling to some degree of jurisdiction?
Yes, absolutely. Thank you, Governor. So during Governor Deal's administration, a couple of things happened. Well, 3 big things happened in appellate world in Georgia. One is that the Court of Appeals went from 12 members to 15. They have sit in panels of 3, so that's essentially adding 1 full panel. That has historically been called the busiest intermediate appellate court in the United States. How you measure that, I mean, I think it's a fair claim. I mean, I've made that claim before, but how you measure that, I mean, people might have make a quibble with it, but the reality is in terms of the caseload that they turn, it's a very busy and productive court relative to their peer group. Our court similarly, because both courts are courts of general jurisdiction, meaning we don't have like a Georgia Court of Criminal Appeals, we don't have a family division of the Court of Appeals. Whatever the court gets, they get everything. Same for the Supreme Court. There are a few things that the Court of Appeals doesn't get. Now there's very few things that the Court of Appeals does not get. Georgia is. I don't think Justice Warren will run down this trail when she's here, so I won't steal her thunder on the judicial branch. Georgia went from 1776, when we declared independence and said we are our own sovereign, until anybody know when the Supreme Court of Georgia was founded or created? 1845. There was no Court of Appeals, no Supreme Court, no appellate court, no meaningful appellate review of Superior Court, which is our general trial court in Georgia. Until 1845, we created a Supreme Court. Not until 1906 did we get a Court of Appeals. In 1906, when the Court of Appeals came in, I wasn't alive. I know it's hard to believe. But I was not here. But I am told that there was a lot of wrestling and fighting over what would the Court of Appeals do. In other words, what would stay with the Supreme Court, what would go to the Court of Appeals, and then have a path via that court to the Supreme Court. There's a lot of jealousy. A lot of things stayed with the Supreme Court. Matters involving divorce, matters involving titles to land, cases that involved capital punishment, equitable remedies, which are things that are non-legal remedies, like injunctive relief and those sorts of things. So there was this whole category of things that the lawyers in Georgia did not trust this new Court of Appeals to do. And that sort of persisted. until Governor, for the most part, almost all of that stayed until Governor Deal's administration. And there was a review, and there was a general consensus that we want to transition the Supreme Court into a position to be more like the Supreme Court of the United States, which means it's a cert court, it's a certiorari court. The cases that it's hearing are predominantly ones that it's granting an appeal to be heard out of the lower courts. Because the reality is the bulk of the caseload even now is still direct appeals, but it's far less than it was. And so there's still room probably to do some space creating there in the future if the legislature seems so inclined. But all of that shifted essentially except for two categories. Capital cases, which has historically been understood to mean murder cases in Georgia. I'll spare you the legal discussion of that. But they come to us direct appeal. So if you're convicted of a murder and you file an appeal, it comes to our court. You don't even you just bypass the Court of Appeals and come to us. And same for any original constitutional question. And by original, I mean one that we haven't decided before. There's no test that we've articulated for the Court of Appeals to apply. If we've already said this is the test you apply, then in that case you can go to the Court of Appeals and they can apply the test. And if we think they got it wrong and it's a big enough deal, we can grant cert in that case if we needed to. But that shift really pushed a lot more original jurisdiction of direct appeals into the Court of Appeals. They gained three seats, one whole division, which has helped them take on that extra caseload. Our court went from 7 members, which it had been for half a century probably, to 9 members at the same time and expanded. Now, that does help our ability to process because you got more folks. But because we don't sit in panels, it's not a proportionate reduction in the workload because all of us are still handling all the cases. We're just not the primary author on 1/7. We're the primary author now on 1/9 of the case work that goes through there. But we're all seeing all the cases. Whereas on the Court of Appeals, if you add a division, the chances of you seeing any of the cases on that division are minuscule. Occasionally, they will sit as a bank, en banc, as a court to hear an appeal that, if the people don't like the 3-judge panel's decision, they can ask that court to hear it as a court of 15, which they occasionally will do. That's very rare, statistically speaking. So most of the stuff, you only hear what's on your panel. So when you take your panels from 4 panels to 5, that's a significant decrease in your workload. But they needed it because they gained other jurisdiction in that respect. So. Yes, sir.
I know you mentioned uniformity between the judges' opinions in your court, but in your judicial experience, how exclusive would you say, or dependent of, determining law of public or of personal opinion? So you said in your experience with your members, is it pretty exclusive, or can you see their personal bias come through?
Okay. The question is when I'm working with my colleagues, do I see personal bias in their work?
In determining law or the case?
I will say it has not been my experience at all. I mean, I have not encountered an appellate judge that articulated or gave me any reason to doubt that their purpose was to find the correct answer to the law. Now, people disagree about how to do that and how to approach that regularly. But I don't know. I mean, it would be improper for a judge to have an outcome preference. And
So I guess bias might be a little bit harsh of a word to say. We can just call it personality.
Yeah. Well, I mean, everybody has their own sort of quirks and personalities and how they approach their work. But you wouldn't be a good judge. Justice Scalia had a famous quote, says, "Show me a judge that personally agrees with all of their decisions and I'll show you a bad judge." Paraphrasing, he was more eloquent than I am. But that's the gist, and I think that's true. I mean, we render opinions regularly that, I won't speak for my colleagues, I'll say for me, that if I was unified king of all the world and could make up the rules as I went along, that would not be the answer. But that's what the law demands in this case. I have to give that, I mean, if I ever don't follow that, then I might as well never follow it, right? And I'm useless as a judge in that scenario, because why have any other branches? If judges are free to simply decide the law is what they want it to be, we go back to protecting your powers and protect the separation of powers. If the judicial branch adopts this philosophy that the law is what I want it to be, what are you going to pass as a legislature to stop me?
How do you feel about judicial policy making?
It's not the role of the judiciary to make policy. I mean, it's not even a question of what I feel. It's in our system of government, it's objectively not the role of the judiciary to make policy. Administering the court, you make policy. I mean, you make your own policies, like within your court, but make policy for the public. Because if the court can do that, there is no value or need for the other two branches. Because if the legislature passes a law, the governor signs it, and then when it goes to court, the judiciary can say, this is what it means. We don't care what it says. This is what it means. You got one branch. You don't have three. You got sort of these advisory people that are just giving the courts, paper for them to rewrite. It doesn't work that way. And it's the least, particularly in the federal system, it's also the least accountable to the electorate branch. There's all the more reason for it not to be in the business of making policy.
Would you then argue maybe the Supreme Court of the United States has granted a little too much power over the years?
I can't.
I wouldn't argue about what they do or don't do. I can't in this job. They do their job.
I always say that they're able to make those policies based on their power. You just talked
The power of the judiciary is a great and terrible power.
great and terrible.
Do you and the other justices like hang out?
Only the cool ones. I see they're recording, so I won't list. Right? Yeah, we do. We socialize. I mean, the reality is we do more hanging out. We go to lunch on a frequent basis. My home is in Dalton. My children are in Dalton. I have a junior in high school, a freshman, and a second grader. And so it's got to be a special occasion to stay and do social. And that's not because I wouldn't want to, because my first job is dad and husband. I mean, they're only going to be there a certain number of days and years, and so I have responsibility there. But yeah, we do. We socialize, and we go. The Supreme Court of Georgia regulates the practice of law, so we have authority and oversight over the State Bar of Georgia. So we also go to like annual meetings and mid-year meetings of the bar as part of our responsibilities. Well, while we're there, there are social functions. So it's a great group to hang out with. I'll say this, he's getting ready to retire. Justice Robert Benham is my colleague. It is freaky weird the first day you walk in and Justice Benham, who is an icon in Georgia law, first African American member of the Supreme Court of Georgia. He was one of the first African American students at the University of Georgia School of Law, graduated from Tuskegee, came to law school there. He was the second graduate who's African American from our law school. Hyper successful trial litigator and lawyer. Went on the Court of Appeals and then has been on the Supreme Court now for 30 years. So when I was a law student, he was already a hero, right? To Georgia law, to the legal community. And to walk in and you sit down at the table and there's only 9 people at the table and one of them is, Robert Benham. You're like, am I in the wrong room? So he's leaving. But the ability to socialize with him and listen to his stories and be educated by his experiences, that's invaluable. I mean, if he starts talking, I'm not leaving because he's got great stories. He famously tells the story of having been a governor's intern for Lester Maddox. I don't know if you've heard that, Governor. There's history there. I don't think Governor Maddox was aware that Robert Benham is who was hired for that internship. But they ended up having a long and positive and productive relationship in an era when that was not expected or common. And so he is an excellent, for me at least, an excellent example of someone who has always worked to find relationship in all his way through. Even when you disagree, find relationship and keep moving forward based on relationship. And so I'm thankful to have him as a friend and a colleague. But yeah, we socialize and we hang out. We actually even went to play basketball one time, and it took us a few months to recover and everything. We may get ready for basketball again soon. I see. Are we running out of time, Governor?
We're about there.
Okay. Well, okay. I will say this: much to the disappointment and chagrin of my children, I am present on social media. So if you have other questions, I mean, I'm on Facebook, I'm on Instagram, I'm on Twitter. They don't let me be on Snapchat. They just absolutely barred that. I'm out. But if you have questions, I'm serious. If you have questions, if you want to come visit the state Supreme Court Judicial Building, and you're coming down to Atlanta sometime, and if I'm there, you get a tour. Come on down because it's your building. I tell people all the time. I mean, if you're paying taxes, it's your building. So come on down and visit us. But if you have questions, let me know. I look forward to staying in touch with those who want to.
Shoot my hand.